present and voting. Assuming without admitting that he had 137 members in the chamber, there was still less than one half of the 275. And by necessary implication, that exercise that he engaged in or supervised is a complete nullity.
As a result, when the House reconvened on November 30 with a minority boycott, the majority were mindful of having the appropriate quorum before proceeding with business of the day. First Deputy Speaker, who presided, ordered for a head count which put the number at 137 members. Joseph Osei Owusu, however, insisted he was eligible to be considered as a member of Parliament present and voting, hence the number present and voting was put at 138. The rejection of the budget was rescinded and subsequently approved. The NDC in Parliament took issue with this and raised the point of law on the ability of the First Deputy Speaker to preside and be counted for the purpose of quorum.
The Speaker shall have neither an original nor casting vote. We all know for purposes of today that the person presiding and the Speaker for today was the Honorable Joseph Osei Owusu of Bekwai as Speaker. He has no business counting himself among them, and therefore, as far as we are concerned, today's vote reflected another 137 by those who respect the tenets of the Constitution and the standing orders of the Parliament of Ghana.
Consequently, Justice Abdulai filed to the Supreme Court to demand the outcome of the said proceedings to be nullified. But the Apex Court, with Justice Jones Doche presiding, disagreed with the stance of Justice Abdulai. The court found the actions of Joseph Osei Owusu, who is also Member of Parliament for Bekwai, consistent with the dictates of the Constitution, and rather declared the provisions of the standing orders that barred deputy speakers from having their casting votes while presiding as unconstitutional. The judgment has been criticized by a number of Ghanaians, including former President John Dramani Mahama. Critics argued that the judgment was an affront to the practices of the House. The former president even impressed upon the plaintiff to seek a review of the decision. A month after this decision, Justice Abdulai has applied to the Apex Court for a review on grounds of miscarriage of justice. According to the review application cited by Citi News, the applicant argued that the Supreme Court perpetuated a miscarriage of justice because the ordinary bench did not consider the legislative antecedents in Ghana on the original vote of a deputy speaker or any person presiding in Parliament as borne out in the 1957 Constitution, the Parliament Act 1965 at 300, and continuous effect of the Constitution and Provisions Decree of 1969. According to the applicant, the ordinary bench failed to consider Article 297H of the Constitution and Section 10 of the Parliament Act 1965 in interpreting Articles 295 Clause 2 and 104 Clause 2 of the Constitution.